Okay, good evening, everybody. Can you all see my slides? Can you all see my slide? That is very important. Okay, can see. Very good. So, I need you to have with you this Rules of Court 2012 because we are going to discuss the past year question. So, it's very important. I believe most of you are conditional pass student. So, it's very good that you got a conditional pass for the past exam. You just left with one paper to do. And as a tip for your revision, you must be familiarized with rules of thought. Okay, most of the time, I believe that you have done your revision, isn't it? So, to cover unexpected area of law, it is best for you to just flip through these rules of court before you are sleeping. So very important, huh? Okay, these are the disclaimers as usual. I would like to make I'm just about 1 month away from my final law call, but I'm still not officially a lawyer yet. So this class may contain errors. So bear in mind that, huh? Okay. And these are the time. The slides I'll give you at the end of the class with modifications. So don't worry. You must be able to have good time management during the examination, okay? Because you can't be perfecting. I have received a few calls from the students after the examination in which they all argue the same problems. They do not have adequate time to answer all the questions. So this is a little bit pity to be a reason to fail. So time management is very important. Do not perfect the questions. Move on with important points stated. Okay. Okay, I think yeah, okay. Please remind me if I'm being too windy, huh? Okay. So we'll start with the first question. Okay. Question 1A. Prakash commenced an action by writ of summons against Darshan at the session court in Johor Bahru. So after an unsuccessful attempt to serve the writ of summons personally on Darshan, Prakash made an ex parte application for substituted service. So normal service is not able to be done. Prakash made substituted service. We call it as SS, huh? In his ex parte application. So Prakash did not disclose that Darshan traveled very frequently to India for business and to visit his children who study in universities in India. Although Prakash knew about this fact, so Prakash here deliberately conceal some facts, you can see, okay. Then Prakash obtained an ex parte order for substituted service. The order for substituted service stipulated, because this is the so-called the instruction given by the court. So I think I need to mark something. So this is the instruction of the court, and then uh, this what we call the writ of summons must be served on the defendant Darshan by advertisements, New Straits Time, and also the Star on 2 consecutive business days. So the rules have been given by the court. You must follow exactly. Okay. So what Prakash did in order to save the cost of advertisement, Prakash only advertised in the Sun newspaper on Sunday and also 2 days later on Tuesday, public holiday. Probably the slot of advertisement is available that time and is quite cheap for him to do so. So after the substituted service by advertisement, still Darshan did not appear because substituted service is another form of acknowledgement because writ must be served, correct? So the defendant knew he got a summon from the court. So the other way that substituted service is aiming to do is to publish this. Oh, so and so, Chi Hui Bing, my name. Got rid of someone pending action in so and so court, High Court JB, for example. So after the whole thing, Darshan still did not appear. So Prakash obtained a judgment in default lah, of appearance against Darshan when Darshan failed to enter appearance. Okay, in within the period stipulated in the advertisement. So Darshan, you are to represent the defendant now, engage you to be his solicitor. So advise Darshan. So question very clear. We are for the defendant. Okay, in civil proceeding, you are only acting for one party. In most of the time, the question will be formulated that you act for one party. Either you are for the plaintiff or you are for the defendant. Very important, eh? Okay. You must know what is your role to play. Okay. Otherwise, your question will not meet the purpose. Okay. So what happened is, eh, okay, so this is my suggested answer. Okay, so Prakash had actually obtained a JIDA against Darshan under Order 13. So put the rule, the order, please, following substituted service of the writ. Okay, as Darshan solicitor, so be very clear what you are playing, what role you are playing. So I have identified the following issues to challenge the said JIDI. In a very simple word, that you want to set aside the JIDA. So you must highlight whatever points that is given in the question. Number one, the mala fide part of Prakash application for substituted service. You must be very clear that the court is a place to serve the justice, and the truth is very important. You cannot play fraud. You cannot play foul against your opponent, regardless of whatever reason lah. Okay, so the fact that Prakash knew the Darshan is actually always traveling to India for business purpose and also to visit his children there is one of the important ground. It shows that when he's applying for substituted service, because substituted service you apply by way of notice of application supported by affidavit. Affidavit is a sworn statement made by Prakash. Inside that sworn statement, you must verify every truth that you are knowing. You cannot just disclose the part that is favorable to your case. This is wrong. So you can actually oppose this based on this ground. Okay. And Prakash non-compliance with the order of substituted service. Very clearly, the order, the ruling given by the court is, you see, they should have advertised in New Straits Times and the Stars on 2 consecutive business days. But Prakash, in order to save cost, advertised the way he wanted it to be, not the court wanted it to be. So this is also wrong. Okay. And because of the wrong things done by Prakash, the whole JIDA is not regular. That means there are technical errors in regards to JIDA. So Darshan need not to show any merit of his case, but can set aside this irregular JIDA as of right. Okay, very important because of the cost issue later. So how you can argue is, mala fide intention of Prakash, so you can set the bad faith of this Prakash not disclosing the fact. Okay, put it in your own words. This is just a reference. So the law of substituted service, you must mention Order 62, Rule 5, and also Practice Direction 1-1968. Okay, you have the latest ruling, but this is what being used by your LPQB syllabus. So I think you just follow. And case of Nimrala, do not regurgitate too much on the laws itself, but rather you focus on what is relevant to Darshan's case. See? So Prakash apply, okay, to show that you know lah. The omission of full frank disclosure in Prakash affidavit during his application for substituted service is valid ground for how to oppose this JIDA lah. Okay, so you further elaborate swearing on this affidavit. The deponent must be honest, must be making full frank disclosure. Okay, because substituted service means you put it alternative way of serving the writ, That means your conventional or normal way of serving the writ had already failed or your effort is futile. So this is why you go for substituted service. And normally substituted service is made by a single party application, ex parte application, meaning the plaintiff is the one that only going for uh, the court to plead for substituted service. So the honesty of the applicant during the hearing process is utmost important. Okay, so this substituted service is already not justifiable by hiding the fact that Prakash knew Darshan is going to India. No, he's not evading services. He's just going for India, and Prakash knew it well. So JIDA, as a result, is actually irregular. Okay, very simple. So non-compliance with the substituted order by Prakash is another ground. Okay, so what you do is you regurgitate what is the order of court, namely by advertisement in New Straits Time and start on 2 consecutive business days. But Prakash did not do so, okay, to save cost. So, and then you must refer to your Order 62, Rule 5, Sub Rule 3. Okay, I think it's good time for you just to flip through now. Okay, whereby if substituted service is provided by the court as order, okay, Prakash should take all the steps as the court directed. So you cannot, 10 rules are there, you just follow 5. The rest you don't follow. Cannot. Okay, strict requirement must be adhered to. Otherwise, the service is bad. Once the service is bad, the JIDA that entered against Darshan shall be deemed irregular. Okay, so this is another point that you must put in your answer to oppose the JIDA and set it aside. So this is roughly the frame that how you set aside, because this is a procedural paper. It's very important that how to say, you must put down how to set aside. Okay, after you argue the substituted service is bad, the mala fide intention on part of Prakash, then you can say that, oh, according to Evans against Batlam, Darshan can set aside as of right, meaning that I do not need to show to the court, oh, why I did not enter appearance. Is there a good defense on my part? Okay, no need to show any merit at all. Means I can automatically, okay, I just set aside because the JIDA itself has contained so much of technical error. This is what it means by set aside as of right. Okay, so the procedure is provided. This is what we call Order 42, Rule 13. Order 42 itself is for judgment per se. So Order 42, Rule 13, to set aside, you must set aside within 30 days. If let's say 30 days is over, extension of time, remember always, if let's say the time frame, okay, is over, under this rules of court itself, you must always go for extension of time first, then only you go for setting aside application. Important because you must get the timing first. Otherwise, the rules of court is designed and draft for the purpose to dispose a matter efficiently and expeditiously. So where if the time frame is as stipulated by the provisions are not being compliant or followed by the lawyers, what will happen is there will be a long dragging of cases in the court. So the KPI cannot be met. So this is bad. So always pay attention to the timing inside your question. Okay, general rules for application of time is always order 3, rule 5. And normal application is by notice of application plus your affidavit in support. Simple as that. So mention this during examination, and setting aside is also by filing notice of application supported by affidavit. So in a matter that this is more than 30 days, two applications, one extension of time by notice of application supported by affidavit, okay, and setting aside JIDA is also by notice of application supported by affidavit. So two separate and two distinct application. Okay. So the affidavit sworn by Darshan, what should the content be? You must mention why Darshan did not enter the appearance because his visit and genuine visit to India, and mala fide must go for this ground. Mala fide application by Prakash, okay, and non-compliance to substituted service, and also defense and triable issue in this case, if there's any, just to make your setting aside applications to be the strongest one. Because if you fail to set aside this JIDA, although it is just a technical judgment entered against your client, what is going to happen is your client will be deemed to owe the person money, or be compelled to do something, So you don't want it to happen. Okay, very important, eh? So under Order 13, Rule 8, the court can order the JIDA to be set aside. So you use more, how to say, these rules of court rather than putting your case law. Uh, please put order. If you do not have much case law, I think it's still okay. But the order you must put, okay? And because this is the irregular JIDA, so Prakash will eventually bear the cost. Okay, every single application to the court will incur cost, usually divided half by the parties, or it imposed to the loser lah. I mean, the person that lost the interlocutory application. Okay, or also the trial. There will be cost incurred. So second question, question 1B. Court do justice according to laws as applied to the substantial merits of the case. Okay, non-compliance with rules of court is mere technicality which does not affect the validity of court proceedings. Discuss the above mentioned statement in light of the provisions of the rules of court and decided case. So you must put in your ROC and also a little bit of case if it is necessary. So I have dissect the question into two parts. Okay, this is what I have recognized. It may not be the standard answer, but this is what I recognize. The first part being courts do justice according to law as applied to substantial substantial merits of the case. Means to say the like I have said to you, this is the place to do justice. So the merits of the case is utmost important rather than the procedural rule. Because there are two fairness, substantive fairness means the case itself, I'm not kidding anybody, correct? That means that is the whole truth itself. Okay. This is considered the merits of the case. Other way, I may have killed anyone. I may have killed anyone. I repeat, But the procedures adopted by the prosecution is wrong. So I'm entitled to procedural fairness. So what this is trying to say is they put the substantial merits of the case first. So you use the case of both state trading to highlight the purpose of civil procedure code. Why do we have this procedure code? As an introduction, and then subsequently the important provision under rules of court is Order 1A. So overriding, this is a new, not to say new, this is a inserted. You see, usually we have A or B, all that. After the unrelated provisos of rules of court, means suddenly there's something happen, and then the parliament passed purposely amended or added in these sort of rules just to make the functionality of rules of court better. So Order 1A determine that the overriding interest of justice is utmost important. So the court or the judge must decide the case not just based on procedure or technical non-compliance, because there are some loopholes. For example, I have forgotten the case management date for a certain case. Then my case got how to say struck out from the top. But actually I got a good merits, and by right the justice should be on my side. So how? You cannot just merely focusing on the civil procedural rules alone. Overriding interest is very important. So the famous case here is Megat Najmuddin. And then subsequently you go on and mention there's always a correction, curable proviso for any technicality errors that have occurred. And this is provided under your Order 2, Rule 1, Sub Rule 2. Okay, so Order 2, Rule 1 is like curable provision. Okay. And then secondly, we go on, non-compliance with rules is mere technicality and does not affect the validity of the court proceeding. So this is the second part of my argument. So is it always true that you have to strike a balance? The first statement said the interest of the justice is the almost important. But number two, it says that it argues that if let's say there are technical errors, the validity of the court proceeding can still, the case itself can still go on even though some advocate and solicitors make major mistake. This is arguable. The first part, well agree. The second part, some, let's say, technical non-compliance is merely just technical. It does not go into the jurisdictional matter of a case. It is curable. If it is going to the jurisdictional matter of the case itself, that means the mistake is too fatal until the court feel that, wow, this is no longer a technical error. This is something regarding to the law itself, how the law should have operated. Then this is, sorry, you are out lah. That means to say you are out lah. It is not longer curable with any provisos under any rules anymore. Okay, so you use the case of Lee Teng Xiong against Lee Kian Lan. This is a case of a consent judgment, and Gopal Sriram had actually said that Order 1A must have referred to technical non-compliance of any rules only. Okay, you must make distinction between technical error or jurisdictional error. So you give a few examples, and then you further highlight the case of Dato Captain Hamza. I think these are the cases that you should not miss in your examination. So what are the example of technical non-compliance? For example, you started with wrong mode, you go and if there's cases involving substantial dispute of the facts, you go and give or as rather than read. So this is wrong. But Order 28 Rule 1 specifically provide that there's a curable. It's curable. You can convert what, isn't it? And then spelling error lah, minor genuine mistake that you can go for amendment, slip rule, order 20, rule 11. These are the typical example. Don't write too much that you have known. Just write the important one lah. An example of jurisdictional matter which is not curable at all. For example, you do not obey order 53, rule 3, sub rule 6. Okay, in terms of judicial review, this is very important. Like within 3 months after the decision had been communicated to you, you did not act. You just let it be. You waited 1 year, then you file the judicial review against a public authority. This is non-curable. You might not be able to extend the time as well in this regards. Okay, so very important. And then the writ is not being served according to the rule or the 10, you are not following it at all. Or you enter JIDA for equitable relief. So this is pursuant to Lam Kong against Tong Guan. So this is also cannot be cured. So then you submit. Okay. In fact, court is trying to strike a balance between the interest of justice as well as technical non-compliance issue, because you cannot leave it free flow, rendering the rules of court to be totally useless. Okay, so this is a balance that the court is trying to achieve. Okay. Okay, so we go to question 2. Okay, Pantas Bena Sendirian Berhad obtained a monetary judgment of High Court KL against Lambat Laun Sendirian Berhad. So the judgment is actually fixed at 2.5 million with interest thereon 4% per annum from the date of judgment, and the judgment was actually obtained in September 2010. So bear in mind, okay, it's already, we are looking at 2017 paper. Okay, so already more than 6 years. Lambat Laun had not paid any judgment debt. Okay, so what the Pantas Banner did recently obtain credible evidence. Lambat Laun owns 1 million of shares. Okay, that is about 20% of the share capital in Innovasi Modern, an information technology company which has substantial assets and business in Malaysia. So that means to say the business is within jurisdiction. Please read your question carefully because the facts are being drafted. Every fact would be useful. Okay, so Lama Lao is contractor and they recently complete some public office building works for Ministry of Works Malaysia, and Ministry agreed to pay him a balance amount of 1.2 million in respect of office building project. This payment is expected to be released by Ministry to Lambat Lao in 4 months' time. So Pantas Banner now seek for your help to enforce the 2.5 million that was entered 7 years ago. So this is what the question about. So in order for you to better focus, you must zoom in to the enforcement of judgment chapter, okay, in your syllabus. Okay, so how do we go about that? You first identify the issues. 15 marks, I have identified 5 issues. Number 1 being limitation period, because it's stated here. Where is it? The 10th September judgment. Okay, so 6 years, 12 years still, still within the period to enforce the judgment, because Section 6, Sub Rule 3 Limitation Act provided 12 years. You have 12 years to enforce. Yes, Pantas Banner can still enforce this, but subjected to leave of court. That means permission of the court must be obtained. And then cannot claim interest. This is second point, because it's provided big here. Interest there on 4%. If you calculated altogether 7 times 4, that will be 28%. We are looking at an amount of 500 over 1,000 ringgit. So all lost entirely. Okay. And then how do we enforce a monetary judgment? there are shares here. Shares, you use charging order. And then you have money, 1.2 million balance amount of money. So you use garnishi proceeding. But here the garnishi, this is not garnishi, garnishi is government. So government, how do you do? You must get consent from Minister of Finance. So your short version of answer is you quickly you must identify all the issues and then you write it out and then you elaborate with separate headings so that you are not confused when you are writing. And the examiners also not confused when marking your paper. Very important, eh? So write it short and sweet here. Leave of court to enforce judgment, 6 years lapse. Okay. And also pursuant to your orders, 46 Rule 1A. Okay. So Pantas banner can still claim, but limited to the principal judgment date. That is your 2.5 million. Okay. Interest could not be claimed. Section 6, subrule 3. And you must how to do? Apply for charging order for this 1 million shares owned by Lambat Laun in Innovasi Modern. And then consent from Minister of Finance and Garnishi Order, Order 49. So briefly write it and elaborate with heading. So leave of court, then you talk about your rules, section 6 sub rule 3, 12 years, still okay, can claim, okay. And 6.3, leave of court must be obtained, and this is also pursuant to your order 46, rule 2, sub rule 1, sub rule A, okay. And okay, that is about all. So you must apply for leave of court. How to apply? Subjected to notice of application supported by affidavit. Surely the court will be puzzled why you are sleeping on your action. I mean, throughout these 7 years of time, is a long period of time, you know. So why do you not act? Why do you not responsive towards the judgment? Okay, that is being hammered by the court 7 years ago. So you must state your reason. Okay, and then you go on by saying the interest 4% cannot be claimed. Why is that so? That is because it is barred by your section 6 sub rule 3 of your limitation act. And then subsequently you write this is a monetary judgment. So after getting the leave of court, be systematic. Pantas banner can enforce by way of charging order and garnishi as described as follow. Do not go and write this writ of seizure and sell, all that, not necessary to describe. So because you are running out of time, writing important issues, I think will consume much of your time already. So Lambat Laun actually owns 1 million of shares in Innovasi Modern. So what happened is the set shares, you must go to your order 50. I think best for you to look at order 50 now. Order imposing charge on securities. So number one, if you are looking at this sort of order, you must get the interpretation right. The provision under rules of court did not mention shares exactly. It just mentioned securities. So does the shares in one company fulfill the meaning of you look at your order 50's rule 2, sub rule 3A. Is the company shares in this Innovasi Modern categorized as securities by the meaning of Order 50? Because Order 50 said charging orders to stop on securities, right? So it is so. I mean, of course, I have said the answer out. So you must be clear and spend more time in your answer to argue this thing, rather than go and describe unnecessary like writ of seizure lah, what is writ of execution, what is the this is not so necessary, you know. So how he can apply this Pantas banner? Ex parte order by notice of application supported by affidavit. So you must exhibit inside your affidavit, you must show to the court and file in our electronic filing system the judgment given by the court dated September 2010 and also specify the shares owned by Lambat Laun in Inovasi Modern Sendirian Berhad. Usually in practice, how we do is we go and buy the certified copies of Suruhan Jaya Syarikat Malaysia, the SSM report. This is your uh, otherwise, how the court will know that Lambat Laun indeed own shares in Inovasi Modern Sendirian Berhad. Otherwise, the court might make a mistaken order. So very important, eh? Okay. And then stage one of charging order, any garnishi charging order, you will see two stages. Show cause, tunjuk sebab. Okay. Okay, tunjuk sebab, and then the second stage will be further consideration. Okay, that means to say, what is the subsequent consideration by the court? Okay, so after filing notice of application supported by affidavit, the court shall direct parties to serve a copy of notice of show order to show cause. So very long name, but this is what you must write. Notice of order to show cause. Okay, that means to say show cause order is not yet granted, but the notice to apply that show cause order must be served, okay, to Lambat Laun at least 7 days before the hearing date for further consideration of charging order, okay, and must also be served to Inovasi Modern. Okay, you must know the original parties are just Lambat Laun and also Pantas Bina. Now, the so-called third party, innocent party, totally not related, how to say, the party in the original suit, which is Inovasi Modern. The decision will affect Inovasi Modern. I hope you agree with me because the shares subsequently you are going to take these shares. Suddenly, outsider go into one private companies. How do you feel? If you ever run a company, I will not invite any outsider to own my shares. You understand? So this is why Lambat Laun need to be notified, as well as Inovasi Modern must also take note that there is something going on. Your one of your shareholders owe people money, no money to pay. Now I am coming to seize the shares inside your company. You get me? So something like that. And then the proof of service must be given to the court as an evidence that you did notify the relevant parties. This is provided under your Order 50, Rule 4, Rule 1. Okay, just try to be imaginative. Play a little bit of your brain's neurons to make things work. Okay, it's actually everything is practical. Okay, so first stage we are not finished. As an effect of this show cause order, so Lambat Laun, so what is the effect? If let's say show cause order already granted by the court, the Lambat Laun cannot sell shares anymore or transfer the shares to innocent third party. Sometimes you want to evade the responsibilities. Memang you don't want to pay means you don't want to pay, isn't it? Regardless of any assets, I don't want to pay. See what you can do. Like that. You can't put me into jail, right? Because this is a civil matter. So once this show cause order had been granted by court, you cannot sell, you cannot transfer. Okay. Otherwise, whatever amount that you get from the profits of selling these shares, you will need to pay, okay, the judgment creditor. That is to say, if Lambat Laun disobey the rule, it's okay, fine. But I get the evidence that you are selling this 1.2 million of shares for, let's say, 2 million. So that 2 million ringgit will belong to me eventually. Okay, so this is what is the effect of this charging order all about. And then all these spelling errors. Charging order second stage is further consideration. So hearing time, everybody will be here. The lambat laun will be here. The Inovasi Modern probably will send the representative here. Okay. So at the hearing, if lambat laun fail to show cause to contrary, means why the court should not grant the transfer of shares to Pantas Banner. Ah, I think it's quite hard because you do not pay the judgment debt unless you are willing to settle the amount before the transfer happens. Otherwise, you can actually, the Pantas Banner can proceed with sales of shares thereafter. Okay, be clear on that. And then we talk about the Ganeshi proceeding. So based on the facts here, Ministry of Works had actually agreed to pay 1.2 million ringgit to Lambat Laun because Lambat Laun helped to complete a building office project, right? So money payable by government is actually you must refer to Section 35 GPA, the Government Proceedings Act. Okay, the money can only be attached uh, to this Ganeshi provided the consent of Minister of Finance had been obtained. Otherwise, you see, the whole thing works in a way same with charging order. Now the original parties are just involving this banner and also lambat laun. Suddenly, the government was asked to pay on behalf lambat laun. Is it logical? The government is operating so huge. Everywhere we have government unit. So how on earth that I know that I am liable to pay this sort of amount? So if the rule is not strict, for example, suddenly corrupted government official may just say, oh, actually, I am issuing this money on behalf of so and so. But actually, there is a corruption involved, So strict rules here. So try to focus on real life. Then you get the rationale of the ruling behind it. So garnishing proceeding, since Pantas Banner is a JC, a judgment creditor, obtained judgment for monetary sum of 2.5 million and Ministry of Work Ganeshi here is within jurisdiction. Okay, because Ministry of Work in Malaysia and indebted 1.2 million ringgit to Lambat Laun, judgment debtor. The meaning, like I said to you, you must focus. Is that considered money? Usually, Ganeshi proceeding is target on the bank account. It means I have a deposit account of 1 million ringgit in Maybank. So I garnish Maybank, So ask Maybank to pay on behalf of my behalf because I refuse to withdraw the money out from the Maybank to pay. So like that. So this is government. So you must satisfy the meaning of Order 49 Rule 1. So you must go to be familiarized with the operation of the proviso. And straight away, don't copy out the whole number, the rules of court. Otherwise, I don't think you can score. I mean, it's very difficult. I mean, if you are just copy and paste from this rules of court itself. And plus, the court could order Ministry of Work to pay Pantas Banner any debt due or accruing due to judgment debtor. Why I said so? Because the money not yet issued. The money will be paid in the duration 4 months. Remember the fact? So everything got some meaning one. And to satisfy the judgment and cost of this proceeding. So not only that 2.5 million the actually not enough also lah, that 1.2 million. So everything by right, Pantas Banner should sapu. If let's say, for example, I give you the cost, I mean the indebtedness by the government is 2.7 million. So 200,000 ringgit more. So can garnish or not? The answer is probably you can only include the cost of this garnishing proceeding. Okay, as a lump sum, probably we are looking at 2.5 million plus maybe 10 plus thousand more. Okay. So garnishing proceeding, how to apply? Again, ex parte notice of application supported by affidavit in form 98. This is pursuant to your order 49 rule 2. Yeah. So single party, and then again inside this affidavit, you must exhibit the judgment given in September, and then stated the exact amount on the time of application. Because this case is quite straightforward, because no interest incurred, cannot claim interest. So exactly the 2.5 million, and then you must verify that the garnishee is within the jurisdiction lah. Okay, and indeed have indebted to lambat laun. Also, one more important point, this is usually will be questioned by court, especially you have a garnishee proceeding. Because of this Personal Data Protection Act, I told you before, garnishing usually is against the bank. So the court first question will ask you, how do you know this fellow, this judgment debtor, has got account and also this money inside Maybank? How do you know? Are you getting it with some sort of illegal sources? You have spy in Maybank or what? Or you have spy, commercial spy inside this lambat now? So you must verify uh, by showing credible evidence, because the fact mentioned credible evidence, so I just copy as mentioned in the fact. Otherwise, you need to show in real life practice. And again, Ganeshi has two stages: show cause and further consideration. Just make it simple. So Order 49, Rule 3, Sub Rule 1, service, like I told you also in charging order, all parties must get to know. Uh, the Ganeshi, the ministry must know it, and as well as the lambat laun also must know that, oh, I get Ganeshi lah. Oh, my account, my money there is going to get dissipation because of this order. So important, you know. Okay, so service is important 7 days before. And as what is the effect of let's say for example you have this show cause order, usually everything is frozen, freeze lah. 1.2 million, the Ministry of Health cannot pay anymore to lambat laun, even though the process, I mean, is still pending for the hearing of this Ganeshi proceeding. Cannot pay. Otherwise, it will issue in 4 payments. By the time you have this Ganeshi proceeding, probably you are left with, after 2 months, for example, you are just left with 600,000. Alamak, then you'll be blaming the lawyers lah. This is not good, eh? Okay. So stage two is further consideration. It's just like a hearing lah. It's a hearing whereby the judge will be sitting, and then the parties will be arguing why the said Ganeshi order should not be granted by court. What is your reason? Usually no reason lah. Unless the debt is settled. Okay. And otherwise you can show, oh, I actually don't hold that money, hold that money on trust. That is another reason that you can raise. I mean, the defendants can raise lah. Okay, so finally, I think Pantas Banner can acquire 1.2 million as partial relief lah. Okay, partial relief. Okay. Oh, we must go a little bit faster. So Amir actually owns one condo here in Petaling Jaya. So in July 2016, he decided to rent the whole unit to get some side income. Thereafter, he managed to get a tenant, Jenny. So both of them enter into a 3 years tenancy agreement. In the beginning of this tenancy, Jenny always pay lah, because I think the relationship is quite good from the beginning. But things turn sour when Jenny start delaying her rent uh, around December 2016. So until now, Jenny not paid rental for consecutive 5 months. So Amir come for you. So you are representing Amir here to seek for your advice as on how he can recover the outstanding rent, as well as the vacant possession of the unit. And Amir wish to dispose this matter as soon as possible. Okay, so the question asks, number one, first give you, okay, there's a tenancy agreement, well and good. And second, there's a breach of this tenancy on part of Jenny for 5 months, never pay. And then the remedies sought, this I think are the critical points that you should consider in this answering this question. Number one is the outstanding rent, 5 months. Okay. And number two is the vacant possession. And Amir further asks you whether any fast track available. Okay, so my suggested answer is as follow. So okay, I will say the tenancy is valid and enforceable because they spent a whole paragraph just to describe the tenancy agreement. So I will just put a small remark lah, even though I know this is not about contract act, but still I'll put a little bit. And since the remedies sought are to recover outstanding renters, I will put it liquidated damages. That means monetary damages. Okay. And this is calculable. I mean, you can calculate lah. 5 months inside the tenancy agreement surely will state 1 month rental 6,000 ringgit. So 5 months 30,000. So this is quantifiable damage. So and vacant possession. Vacant possession means you want Jenny to get out from this condominium immediately, right? So this is compelling the of an individual specific performance. Okay. So Amir could neither means cannot both way. Can he go for order 14? I don't think because it only recovers money, but not specific performance because specific performance of a certain contract, if you want someone to perform, usually tenancy agreement will have but this is not stated, better you don't assume. But under Order 81, it only compel vacant possession, but not the money altogether. So you are just doing half of the job. So cannot. So I will also submit distress action, also cannot, because distress action means you ask a court officer, looks like a police lah, okay, to seize and sell whatever the items, the furnitures, the TV set, the fridge inside the condo, which belongs to Jenny, in order to pay the outstanding renters. This one also, there's no fast track lah, I'm trying to say with these submissions. Therefore, Amir could commence a writ action, okay, normal conventional way against Jenny, open the default of payments of rentals for what is the cause of action here? Breach. Okay, breach. So Amir will this is normal way because Jenny is in an individual defendant, so AR registered post or personal service. Okay, Order 10, Rule 1, Sub Rule 1. And you can use the case of Goh Teng Wu because I think it's quite commonly used. And Amir could dispose the matter speedily because the question still fall back any fast track or not. Yes, there is fast track in the event of Jenny's default. If she never enter appearance, also cannot enter. But when she default in entering defense, there's a distinction, JIDA and JIDD. JIDD, you can enter. Okay, because here we have liquidated damages and also vacant possession. So I need you to refer back to your Order 19, Rule 6. Order 19, Rule 6. So the right provision is Order 19, Rule 6, which cover for your liquidated damages as stipulated in Order 19, Rule 2, plus your Order 19, Rule 5. That means possession of that particular condominium. And the case that I'm relying here is Lampong against Tongguan. Okay, and as most of the case, because JIDD plus equitable relief, do not assume you can take the way easily. You must, number one, get the permission of the court. Okay, so leave of court, this is a general application, always by notice of application, supported by affidavit. And after the court had granted the leave, so you must prepare your draft judgment, and then you must clip together all the writs, pleadings, as well as the affidavit for services. Okay, that means you have truly served the writ and also statement of claim to Jenny, but Jenny never respond, never enter defense. So everything I click together on top of that, my itu ada draft judgment for the registrar approval. So at the end of this JIDD hearing, if let's say the court allow, then you can get an enforceable judgment. This is the only fast way. Otherwise, if Jenny enter appearance and then file her defense, then I'm afraid there's no fast track for me. Okay. So question 3. Okay, ABC Berhad is a public listed. I, I haven't checked. You can follow me so far. So sorry, I'm just going by the speed trend because I don't want to drag matters too long one. You can follow me? Yeah, thank God. Yeah. So got one response, and this there's good news. So question 3. ABC Berhad is actually a public listed company with subsidiaries like office, uh, projects and manufacturing businesses. Okay. So in 2006, ABC entered into a distribution ship agreement with XYZ, a small distributors whose majority shareholder is a childhood friend of managing director and controlling shareholder of ABC. So things went very well between the two parties for 10 years of time because mainly because of the friendship between MD as well as the shareholders lah, okay, of XYZ. But unfortunately, in 2016, there was a fallout between the two companies' majority shareholders, with each feeling that he was betrayed. So there's a betrayal of friendship here. So as a result, bitter disputes arose between two companies in connection with their distributorship agreement. Okay, so the friendship is the foundation of this distributorship agreement. Then the whole thing does not went smoothly. Okay, so June 2014, ABC filed writ of summons against XYZ, making numerous and lengthy allegations against XYZ and claiming for huge loss and damages against XYZ. So as a consequence, XYZ's banker had come to know about the pending litigation and had substantially reduced the trade and financial facilities which it previously granted to XYZ, causing hardship to XYZ financially. So ABC's allegation and statement of claim relate to A, alleged breaches which occur in 2006 to 2008, and personal matters which occur in year 2014 and do not have connection at all with the company's contractual relationship and also transaction under the said distributorship agreement. So XYZ came to you. So you are to represent the defendant. Be clear. So and ask you a few questions. Can XYZ summarily and quickly dispose of the suit without waiting for full trial? So usually summarily and quickly dispose zoom in to a few proviso. Either it's a summary judgment or it is a striking out procedure. But this is always the case, but not it is in exceptional circumstances. It may not uh, it is not like that. So be very careful. Do not get tricked. Okay. So you identify this is the background facts. So what are the reason for lawsuits, and then subsequently XYZ banker reduce the probably the loan or the overdraft facility. So causing vexatious impact on the defendant. This is XYZ in this case, and then allegation A here in the statement of claim contain of limitation period issue. And allegation B here contains scandalous allegation. Okay. Nothing to do with the so-called because XYZ and also ABC are companies, registered company. So this is there is a issue of a separate legal entity here. So you cannot mix up personal matters with corporate matters. This is not right in the eyes of law. So how you argue? You argue based on a few headings. First, because statement of claim already been served to you, as a company, first and foremost, enter the appearance and also serve your defense within the stipulated time, 14 days. Okay, by hook or by crook, do not just simply proceed to strike out. Yes, I know it's very interesting that you you identify the whole question is surrounded with the issue of striking out. Good for you. But you must look at the matter as a whole, as in you are practicing as a prudent and reasonable lawyer. So first and foremost, identify, get familiarized with your civil procedural rules, how the court works. First, get this sort of read, get sort of the statement of claim, enter appearance plus far within time. This is prior to any interlocutory application. Okay, I hope you can get me. So general rules, XYZ scenario mahal. So must go by way of solicitor. So, so this is pursuant to your Order 12, Rule 1, Sub Rule 2, and file a memorandum of appearance, and then must submit or file a statement of defense within 14 days. Otherwise, there will be an issue of JID, the judgment in default. People, I mean, the opposing side quickly enter this. Wow, then you susah, man. So you do not want to mingle up with this sort of unnecessary or put your client into problems. So this is the right thing to do. And because when you file your defense, because there's an issue with limitation period, right? Here, the allegation A here. So inside your SOD, you must rebut whatever allegations that put forward by the ABC. Okay, that means you must rebut one by one or average one by one. So this is particularly important in terms of the plea of limitation. So this is pursuant to your section 4 LA as well as your order 18 rule 8. You must specifically plead, oh, these breaches are actually, yeah, no doubt there's might be some contractual breaches on my side, but this is barred by Limitation Act. So I specifically put it out inside my apa nama my statement of defense. So important if you do not plead, the court will ignore lah. Then let the claim to go on. So Simon, okay. So and to dispose, then you go to your order 18 rule 19. That is striking out. Okay. So to dismiss, to answer the question, this is the second part already. XYZ without going into the full trial. That means the fast track here. So first, you must mention if you are going for order 18 rule 19, that is the striking out pleading or striking out reads or any sort of endorsement. You can do it any stage actually throughout the whole trial, but preferably before the trial lah. Okay, so usually the circumstances will be the plaintiff need to establish his case on balance of probability. But in this particular interlocutory application, because you are the one that seek to strike out the application, you bear the burden to show what are the reasons XYZ cannot fulfill. So this is in reference to your lim 1A to the D lah in your order 18 rule 19. Okay, so you must be familiarized. So the burden is on you. So argue this first and apply promptly. Apply promptly. And do not apply everything as a whole. That means to say usually how to say, you do not argue so much. I know there are some favorite people that argue first A or no cause of action. Second is a scandalous reversal. Argue one by one, but actually you just choose one limb will be sufficient, because eventually the effect of this order will be the same. And most of the time, you can see there is some overlapping element. Okay, but my personal advice is you may not wanted to use limb A that frequently. Okay, limb A, that is to say the course of action part. Because simply to say, the course of action, even the weakest one, is still a course of action, a valid course of action, Just that the allegations of the plaintiff did not substantiated or backed by solid proof. It does not mean that the cause of action is not exist. So do not simply go with that limb. You can go with other limbs. The favorite part, my personal choice, B or C. Easy. And abuse of process of court in limb B, how do I say? You are trying to tell the opposing lawyer is not playing a nice game. You're trying to abuse the process of court. So it's a quite a harsh allegations towards your colleague there lah. You get me? So in practice, we often lower down our tone in negotiation, isn't it? Because one day you'll get your turn, isn't it? So you choose B or C. Okay, I hope you can bring that to your mind. This is what I was taught by my senior, and XYZ should apply the striking out procedure by notice of application supported by affidavit. So the affidavit itself must contain some information. So every single thing, it looks like every single civil procedure is notice of application supported by affidavit. Notice of application, no doubt, is like a general format, but affidavit is the one that determine the taste of that notice of application. So the content, the ingredients of affidavit is very important. I think you should highlight this because this is your uh, arguable grounds as well. So the brief background to introduce the court in regards to the long-standing relationship, because the facts already put forward to you, so may as well as just use it. Uh, uh, my personal preference would be you make use of whatever materials that are available to you. It will be better rather than you go and tell whatever that you memorize from the book. Okay, so again, you use the background information and there's a fallout of relationship lah, which is trigger of this lawsuit. So that means to say the whole suit itself is actually mala fide lah. So mala fide is very good challenging point, use that because every single application in court should be lah, and by right lah, should be bona fide. Okay, and what we call XYZ's banker had also reduced the financial facilities due to pending litigation. So that means to say this pleading itself, this lawsuit itself has actually some vexatious, that means annoying, frustrating this XYZ, because the XYZ, as you get from the fact, is a small company. ABC is a listed company. So if I want to kill you, I want to make you to wind up, I just simply find a few suit, then you have to engage, my firm, the Tuan Chris and partner. So you have to spend a lot of money. It's already negative impact. What? Let alone you go and tell the bank, some of the bank will be scared. You get me? So this is vexatious impact. So you can use the case of Pertamina against Kartika Ratna. And the breaches occur from 2006 to 2008 is clearly time bar lah. So time bar does not mean that there is no cause of action. So that's why I cannot opt myself to choose limb A. I prefer to go B. Okay, I'll keep on saying it's vexatious lah, frivolous lah, something like that. So you use the Ronex Properties case here, and in relation to the personal matter pleaded, there's no relevancy, no relevance at all. It's totally scandalous. Okay, in nature. So you apply and focus Otherwise, you'll be spending a lot of a lot of time in arguing all the limbs as provided. A, you argue; B, you argue; C, you argue; D, you argue. So you wasted a lot of time. Okay. And after hearing the application, because there are something more important, Okay. So the hearing usually inter partes means if you find the affidavit, notice of applications supported by affidavit, the other party, the ABC solicitor, will reply also in, affidavit in reply, and then subsequently this application will be heard in the court. So both lawyers need to attend in the court. Then the court will give a decision whether to allow striking out or not. But it's very important, striking out nowadays, because too much abuse and too many people use as a delay tactic to purposely drag the matters. So it is only in plain and obvious case the court can grant striking out. Okay, that is reflected in your case of Bana Builder lah. Okay, and for you to invoke this, the court to invoke, usually Order 18, Rule 19 has the power, but sometimes the court can use Order 92, Rule 4 to invoke this striking out order as well. Okay, inside our notice of application, usually we'll put Order 18, Rule 19, done atau Order 22, Rule 4. Okay, so if let's say, for example, unfortunately, XYZ's application is unsuccessful, cannot appeal further. This is by letters ruling, Section 28, Sub Rule 1C, CJA. If the case is from magistrate court or session court, if it's from high court matter, cannot appeal to Court of Appeal. That is pursuant to your Section 68. Okay, CJA, 1F lah, CJA. Okay, important, eh? So we go on. On 4th April 2014, Nasir was riding his motorbike along a public road beneath the recently completed MRT, okay, when he was hit by a falling object which dropped from the MRT line. So Nasir, actually, due to that sort of accident, he fell and then broke his legs, suffered from rib fractures, punctured lungs, and he was hospitalized for months and unable to, loss of income is there lah, to sustain his hospital bill. So a lot of fees and expenses had incurred on the good self of Nasir. So Nasir's solicitor filed writ of summons against MRT Corporation Berhad for negligence and damages at the High Court of Kuala Lumpur. So as his solicitor, it's a junior one, just like me lah, who is rather inexperienced in civil litigation. So Nasir comes to you as a senior counsel to seek advice. So advise Nasir. So we are in the position to advise our plaintiff here, our claimant here, how he can apply to High Court for early payment. Whenever you see this or turn to elevate hardship difficulty, you will definitely jump to the interim payment already. Okay, this chapter. Okay, so describe the procedure as well as the principles of law. So you can see here, MRT, physical harm, okay, writ already issued, and so what Nasir ought to do. Okay, so Nasir, as usual, standard, I will file this first because whatever you ask for, your 22A here is an interim payment. The so-called, this sort of thing is so-called interlocutory application, So that means the application happens within the process of the trial. So very important, before you do anything, you just don't, without a read, without a SOC, you go and file this sort of interim payment. I do not think, for my short period of my training, I did witness anyone did so lah. Okay, so you must have things ready, then only you file. Okay, so as the pre-trial case management is in progress, you apply interim payment because Nasir is in difficult position because he did not work, he need hospitalized treatment, all that. So you must get it done quick. I agree, but you cannot file without your writ and SOC yet. Okay, so the provision of the law is provided under Order 22A. Okay, so what are the principles here? The principles is provided under Order 22A as well as your Section 25A of CJA, which allow court to make interim payment from MRT to NASE. Okay, usually the whole trial process for civil case is to determine whether the liability has been found on the defendant or not. If there is liability, then the defendant is entitled to pay the plaintiff. You can follow, huh? So Order 22A is a special, special creature, lah. Okay, creature under the statute, whereby before the end of the trial, the defendant was already asked to pay plaintiff. So get it right. Huh? But you must always think the court again is the place to serve justice. No point the trial ongoing, let's say for example, the case involving negligence for Nasir here, ongoing for 3 years, and then throughout these 3 years, Nasir need to cough out his money to pay for hospital bill, cannot work, need physiotherapy, all that. And then after 3 years, what happened we don't know. You see, such a long dragging, and then Nasir was keep on being pressed by his economical pressure, all that. So the court will seek a balance. So strict rules under Order 28(2)A must also be followed. Okay. So interim payment here means partial payment by one party to another. So on accounts of damages or debts, okay, before a final judgment. Okay, please be clear with that. Okay, so the purpose is to make sure the defendant pay plaintiff a certain sum of money. So actually to alleviate plaintiff hardship. So there are two issues here. Plaintiff must have hardship lah. Don't simply you normally you can work, you have no financial issue, you go and apply just to show. Just some people and they'll just once you get interim payment, it will create this sort of prejudicial effect to the court. Oh, this defendant is liable. That's why interim payment is ordered by the court. So you cannot. Okay, you must have a bona fide application. Okay, so the case referred is Media House Sdn Bhd against Koh Kim Swan. If you cannot remember, just remember one case. I think David Chilia is sufficient. Okay, so application here again, notice of application. That one is quite specific. If you refer to Order 22A, it specify Form 33. If you refer to your Order 22A Rule 2, Sub Rule 2, okay? Your Form 33, supported by affidavit. That means the affidavit must show what are the amounts that you are claiming. You cannot be claiming 1 million, isn't it? So the amount of claim must be also tally according to your actual scenario. For example, what I have identified here is motorbike damage. Yes, memang the motorbike was damaged during the accident. There was a broken leg, rib fractures and rib fracture got lung puncture should got, okay, which led to consequential economic loss. Okay, this is true. You can submit all the bills and repair, the hospital bill, all that. You can submit. This is going to help you in granting the Order 22A interim payment. Okay, and you must serve this notice of application and affidavit to MRT lah. So this is 14 days before the return date. Return date means hearing lah. So the court will actually hear this matter and decide whether the interim payment shall be granted accordingly or not. So whatever condition are stipulated in Order 22A, Rule 3, and your Sub Rule 1, A, B, and C shall be determined. So that means to say MRT already admitted liability. So the fact did not say so. So I dismiss. So B, already the judgment obtained on behalf of NASE. That means I'm just waiting for the calculation of total amount. I get some money first, advance some money first. This is under sub rule B. So this is also not stated in the case. So no need to mention. I think the likelihood is sub rule C. Okay. It is highly likely for NASE will obtain a substantial judgment against MRT. So this is the factor that the court will consider when they award Order 22A interim payment. Because like I said to you, Order 22A is a special creature. Before the conclusion of the trial, you already asked the defendant to issue the money. So there must have some strict criteria here. Okay. So again, I submit. This is personal injury claim. Okay. So personal injury claim, you are entitled. Let's say contractual. Contractual, no. Contractual, let's say just commercial contract, and then the fellow, no doubt, is a listed company. I cannot claim also under Order 22A. So be clear about that. So against you use your rules of court lah. I think this MRT is likely to be a public authority because in order for you to claim, the other fellow also must be financially strong, you know. It cannot be just like me. I myself have no money, then I ask to pay interim payment before the conclusion of the trial. Cannot like that. So cannot also. Unless I'm insured lah. For example, I'm a medical professional previously, so I'm insured. My medical indemnity insurance can pay. That is different story. So this is your provision Order 22A, Subrule 3, Subrule 2, Subrule A. But this is not likely here because MRT cannot be, let's say, for example, a person insured or that. Okay, I will submit this is a public authority with means and resource. Means got money. Okay, and it's not government lah, and it's not government because MRT corporations berhad what. Okay, so so all these points I think will be helpful in getting some marks for you during examination. So submit. This case actually draw a similar analogy from David Chilia case, and NASE is likely to get award of interim payment to elevate his hardship. So this is my conclusion. So question 4. Account a landowner has actually sublet part of his land in Ipoh to BC Builders Sdn Berhad, BCB, for storing its machinery and equipment. So after expiry of this tenancy on 20 March 2017, BCB moved out its machinery and equipment from Account's land, but actually left a big one, dismantled tower crane components on the land. So on 5th April 2017, Cao received a letter from CLSB claiming that the ownership of that tower crane components belong to him. So when notified of such claim, BCB by its letter dated 21 April 2014 refuted such claim and insisted that tower crane components belong to BCB. So actually, both CLSB and BCB are claiming the tower crane from who? From Akau. Okay, so Akau actually not the owner. Akau is the stakeholder. Remember, stakeholder. I'm just helping you to store, maybe just to let you put the tower crane on my land, but I'm not the actual owner, or I do not have any legal interest over that tower crane itself. Okay, so after several exchange of letters between the parties, BCB and also CSB, who are actually claiming the ownership towards this tower crane, they cannot achieve a mutual agreement. So, and then okay, and then we move forward. So Akau has actually found potential tenant who wants the land to rent the land at good rental. So now what happened? The tower crane was still seated on Akau's land. Cannot rent. This components took a major part of that land. So Akau, being a stakeholder, come for your advice. So quite a straightforward, how to say, a question. It is about stakeholder interpleader. Okay, so you are to advise Akau lah. Okay, so how to go about that? Okay, so Akau is advised to seek his recourse by stakeholder interpleader proceeding pursuant to Order 17 rules of court. So the principles of law you mix with your facts and then you submit in your answer. So Akau is actually confronting with two parties, BCB, his previous tenant, and also one leasing company, the CLSB, who are making adverse claims towards the crane tower in his land. But although there is no pending litigation, however, Akau may actually sued by any of his party in his attempt to remove the tower crane when he's about to rent the land to potential tenant. Otherwise, he's going to face lawsuit anyhow, because if somebody come in, then the tower crane got missing or got destroyed, so he might face lawsuit. So in order for him to protect himself, he better apply to the court to determine who is the actual owner. Who should I give this tower crane to? So this is the legal way. Because negotiations by exchange of letters already fail. So the preliminary of the normal ways do not work. So you go by court order. So you use the case of overseas investment here against O'Brien and the application procedure. Okay, because the suit has not begin. There is no suit number, there's no registry, registration of that particular matters in this our electronic filing system. So you need to start by way of originating summon. Okay, originating summon, OS. This is pursuant to your Order 17, Rule 3, Sub Rule 1. Okay, because no pending litigation. If there's a pending litigation, then you start with notice of application supported by affidavit. Okay, so OS as usual, OS, you do not need to give any statement of claim. I'm sure you know by now. You just give affidavit. Okay, so accounts must go to Commissioner of Oath and swear before the Commissioner of Oath the affidavit in which some evidence or some pernyataan, some statements must be made clear. The account, according to Order 17, Rule 3, Sub Rule 2, account actually claim no interest in that particular crane tower, except the charges or the cost incurred in this interpleaders proceeding. Okay, the crane has totally nothing to do with account. I'm not the owner or beneficiary or owner whatsoever. Okay, so this is pursuant to your sub rule A and followed by your sub rule B. So you go to your Order 17, Rule 3, Sub Rule 2 and have a look. Account does not actually collude. That means tak ada pakat lah, tak ada pakat with BCB or CLSB in relation to the disposal of this crane tower. So sub rule C, account willing to transfer. But I mean, at the all material time, because account wanted to rent out his land, better move it away lah. Better somebody take it, isn't it? So inside the affidavit, account must state his intention that I'm willing to transfer the this crane tower to anybody as the court decided so. Okay, so you use the case of Tan Kim Kwan here. Okay, you can also use the case of Tetuan Kim and this Tay and Salina and Co. So to just the order is more important than case law. Okay, so long you use the right provision, I think you should be all right. So after filing the OS and affidavit, ACAO shall serve the documents to both BCB and CLSB. at least 7 days before the return date or the hearing date. So this is your order for 17, rule 4, sub rule 1. And it is by way of personal service. Very important for you to highlight. That means you must hire a runner or a process server to give the OS plus affidavit to the parties, BCB as well as CLSB, at their registered business address lah. So during the hearing of this OS, the power vested to grant order who to decide is actually provided inside your Order 17 Rule 5, in which the court can actually, in the Rule 1A, add claimant into the suit if they think there are, beside BCB and also CLSB, like I said, the court does not wanted to make any mistaken or wrong order. So any party that come to claim for maybe let's say XYZ come forward to claim, oh, actually this this tower crane is belong to me lah, the crane tower belong to me. So actually the court can them as party. So this is the wide discretion of the court here. And sub-rule 1B, decide and direct the claimant to be plaintiff or defendant as their discretion and dispose the matter summarily or even to proceed with further hearing also can. The court also has power to order costs. What are the fee incurred to have this matter trial? What are the costs that you ought to pay the what we call the count? So discovery also can. You can also proceed to calling witness, but with modification. So this is like a small type of hearing, because the court is in the position to determine this valuable thing. I'm sure the crane tower is something very expensive, isn't it? So you must go through. Sometimes affidavit itself, no doubt, is a sworn statement, but you did not have a chance to cross-examine the witness. So sometimes they make it like a small trial. Okay, so be clear with that, So these are the provision under interpleader issue. So usually you do not stop your answer with OS plus affidavit lah. Then a little bit half hanging, half hanging. And B, describe the procedure adopted by interested party to intervene in pending court proceedings pursuant to Order 15, Rule 6, Sub-Rule 2B, ROC, and state relevant law principles to be considered in intervention proceedings. Okay, and intervention proceedings, that means to say, Qi Huibing, for example, is the plaintiff, and my colleague Gan Xianyang is the defendant. So plaintiff sue defendant. But suddenly, in the whole suit itself, usually is between the matter between me and also Mr. Gan, isn't it? Because he's the defendant. By right, any other person will be deemed to be a busybody if, let's say, they go and kacau the suit, unless it is provided under Order 15, Rule 6, Sub-Rule 2, Sub-Rule B. There's an intervener procedure. That means to say a stranger, by right, I commence my action against Gan. You have nothing to do. Suddenly, my master wanted to intervene, want to campur tangan, want to go and have a look, go and have some matters to be tried. That means to say, already campur aduk, in between the suit that I have with Qi here and Gan. So usually this is subjected to strict criteria. Otherwise, you see, if it is left widely open, you see, who will come? My grandmother will come, my aunts will come, my neighbors will come and give their version of stories, give their so-called interest in the court. And then no habis, the court proceeding cannot finish. By right, it's only a suit between me and Gan, and the case should be disposed fast. But due to so many third parties, so many strangers, it becomes long dragging. But somehow or rather, the court also can allow, because sometimes it's not just between the said matter even though I, as a plaintiff, had chosen Gan as my sole defendant, it doesn't mean that the matter is decided solely. Only got Gan only got the interest. Some people may have some legal interest, This is why intervener proceeding set in. Okay. Usually we see it in what are the cases? Okay, in our legal profession, whenever the lawyer, there's an issue of breach of trust. That means if let's say easy, I take away somebody SPA money and run away, my client can't sue me. The bar counsel, although he's not the party of the suit, can intervene. Okay, can intervene. You'll add in uh intervener Malaysian Bar or Bar Council Malaysia, something like that. So you'll see this. Okay, so the principle of law is, like I said, person who is not a party of this suit to be added as defendant slash intervener against the wish of the plaintiff. Okay, on his own application. That means the stranger, like the bar counsel, can apply on his own, or the defendant can apply. Okay, or sometimes the court on its own motion can add the intervener in, because there is some interest to play. Okay, usually the interest of justice and also legal interest that implicate the stranger. Okay, so the purpose of intervention again is to prevent injustice to the stranger. Okay, so the test here is whether intervener's right is directly affected by the order of the court. So you must always imagine, how to say, think as such. The court is the place where justice is served. I repeated many times, so I hope you can follow it. Every rules designed to serve justice. So why this law is allowed in such? Okay, uh, so the legal criteria will be the stranger must have legal interest. Okay, not just mere commercial interest. This is pegang mining. So otherwise, a lot of parties will claim somehow, rather, I have some commercial interest, and then the threshold becomes very low. Not good. Okay, the stranger must have pecuniary interest, and the application must be prompt lah. That means before the judgment. Otherwise, we already finished the trial, then only you come. For what? I mean, the judgment is already nearly is about a week. Suddenly you say, I want to intervene. You intervene is because you have something to tell the judge, right? You want to say something in the court, right? So only you intervene before the trial ongoing. So this is logical. Okay. So procedure wise, a stranger should make application by, again, notice of application supported by affidavit. The affidavit is undoubtedly is sworn and must display some sort of evidence that he has legal interest. Uh, Okay, and the applications, I mean, the notice of application together with the affidavit must be served to all the plaintiff and also the defendants. Okay, so like I've said, before the judgment, you must intervene because as a stranger, you have something to say in the court. You must do it fast. Okay, Hong Leong Finance against Stakeholder. Okay, 4C. What is 4C? Okay. What are circumstances a court may refuse leave to a party to amend his pleading? So amendment of pleading, you refer to your Yamaha against Yamaha Motor and also the Hong Leong Bank case. So long the application, regardless whether it's delay or not, so long it's bona fide, it does not change the character of the whole lawsuit, and then it does not actually prejudice the defendant or the plaintiff or the other opposing party without having the said prejudice can be compensated by cost. Usually the court will allow the amendment. Okay, usually will allow. This is the general position. But I think this one you can copy from your book lah. If let's say the amendment itself is mala fide, just I want to delay. Like I said, you wouldn't get any cent until the trial is concluded, right? So you just keep on putting amendment here and there just to delay process. So this is not bona fide. It's not allowed. Okay. And amendment to withdraw an admission consciously made. Admission is something very powerful because, like I have said, plaintiff need to establish his case. Here, admission is coming from the defendant already. So it already lightens the job of the plaintiff, not just plaintiff, but the court as well, you know. So the court need not to go through so much of paperwork, you know, documents. Wow, you see, go through the witness statement, so much of work. If let's say the admission is coming already from the defendant about certain matter, maybe not the whole, but certain matter. So you cannot suddenly say that I do not admit. You have to prove. So this is be fair to the court as well as to the plaintiff. Okay. So amendment to raise cause of action after the action being commenced. So this one also cannot. This is a brand new action. You should file a new suit. Okay. And amendment that change a character of the suit into another. For example, turning a negligence suit because the elements to prove is different. Negligence, suddenly you want to go for defamation. Entirely different. The ingredients of the thought, we are looking at different elements. So you are virtually delete the whole pages of your statement of claim, you know. You are changing it with the defamation part. You are telling that, oh, statement are defamatory, you refer to the what we call the claimant lah, all that can like that. Cannot. Okay. So amendment to add party or raise cause of action after the limitation set in also cannot. And of course, another is delay. You apply the amendment the day before the trial, for example. How can? I mean, people already file in bundle of documents, witness statement, and everything. Then suddenly you want to let the whole process restarted again. This is not fair at all. Okay. So logic. When you think how to say the reason behind why the rules is there, I think it will make your life easier. Okay. Well, almost 7. I think I need to stop by 7 o'clock. Why not we finish this question and then probably we can continue in the next session. Ayo, sorry for my time management. It's too long. In January 2014, Abu intended to purchase from Fatima her car worth 150,000 ringgit based on representation that she was the owner. And then Abu conducted a search with JPJ with the result confirms Fatima's ownership of the said car. So in reliance to the search, Abu proceeded to pay Fatima purchase price in the same month. So around 4 months later, when Abu wanted to make the official transfer of that car's ownership, he found out, wow, Fatima was not actually the owner by a second JPJ search. So as a result, he was not allowed to register or even transfer the car to his name lah. Okay, so he therefore suffered loss. In his view, JPJ was at fault because they failed to ensure the records were accurate and proper, so resulting two separate searches to display different results. He also did not take immediate action on the loss, so he left the how to say the negligence on the part of JPJ. He sleeps on his action. So Abu now comes to you and seek for legal action. So I mean to say, how to recover his loss, and you are to advise the plaintiff Abu. So there are issues of misrepresentation, JPJ's negligence, mistake as to ownership, and also Abu, I think, can commence actions against JPJ, and also Fatima. So these are the cause of action. So what are the issues? In advising Abu, you can actually advise Abu to commence with action against following party. So important to mark the word read action because there will be dispute of facts. Okay, and JBJ for negligence and also Fatima for misrepresentation or as in the mistake pursuant to the ownership, okay, of the car. Okay, so this is a contractual action. Okay, so suing JBJ, you must first identify that JPJ is a public authority. That means it is subjected to your PAPA, PAPA. Okay, so 36 months are already lapsed from the incident because the negligence occurred in January 2014. Now it's already, on the time of examination, is already 2017, August, it's already gone. So Papa 1948 is absolute and very strict, and the court has no room to extend the time at all. So even though Abu has a valid cause of action, yes, JPJ might be negligent, but you are time barred from suing JPJ. Okay, so the word absolute here is very important because inside the statute, the PAPA statute itself, there is no extension of time provided. Okay, in the event of your limitation act, you look at your section 24, section 28, 29, all that, section 15A, all that actually provides room for extension whenever there's a fraud latent defect, all that, acknowledgement of payment with a written statement. Okay, these sort of things make limitation act to be a relative. I mean, it's a qualified limitation period. It's not a strict one. The court can still expand it, subjected to certain condition. Okay, whereas Papa, the CLA, no, absolutely, the time expired means bye-bye. No case for you. Okay, get this clear. While suing Fatima is contractual action. 6 years, section 6. This one quite simple. So you commence writ action and individual. So writ of summon and statement of claim must be served to her by AR registered post, or also by personal service. Okay, and the remedy sought was not clearly mentioned. So it was only stated loss. So presumably the claim is to rescind the sell purchase agreement and to recover 150,000 and other loss incurred. Okay, logistic. So cannot use the car, labor cost, etc. So in terms of liability, so Fatima here would likely blame JPJs. Okay, because whenever you claim a mistake and misrep, I hope you did not forget the Contract Act 1950. The so-called the plaintiff must also exercise due diligence to discover whether the mistake or the misrepresentation or not. So Abu actually, in this case, he exercised due diligence. He did not just believe what Fatima's claim that, oh, that car belong to me, so I just pay. No, I made separate search with JPJ. So that's why sometimes you need to put this sort of substantive facts. Okay, so I submitted because of this, the remedy sought is somehow it's not clear. So I think Order 14 and Order 81 has no application. Okay, and Abu Basho would be Fatima's default lah, whether JIDA or JIDD, then it can be disposed of faster. Otherwise, a full trial will be necessary. Okay, and we go with yeah, 5B. Penny initiated a suit against JSB for breach of contract. In statement of claim, Penny alleged pursuant to the contract entered between the two parties back in 2015. So this one, no time limitation period issue. So he will actually pay 1.5 million to JSB for investment, and in return, JSB will pay him profits of dividend annually. However, until now, he had never received any return. So Penny never returned having any investment for her. I mean investment returns. Okay. JSB, on the other hand, holds the position that the company had never entered into such contract, and there was never a written contract between the parties. So the money paid to JSP was actually merely for repayment of debts owed by Penny to JSP. This is very common. One party will say that, oh, my money is for this purpose, but the other, the receiver of the money will claim that, oh, actually, he owe me that sum of money. That's why the money is meant for. So therefore, the allegations made by JSP cannot be substantiated and baseless lah. So pursuant to this suit, JSB engaged you to represent them. Statement of claim was served on you last week. So 1 week ago, be careful with the timeline because like I said, you cannot apply anything until you enter appearance, enter defense. So these two rules, please bear in mind because sometimes the marks here a lot. They are not just asking you to strike out, okay? Even though your client insists Penny's allegation were baseless. So it looks like a striking out question, but is it really the matter here? So my opinion is such. Okay, so in advising JSB, like I said, company, same like our previous question, you must enter appearance and defense within 14 days as stipulated under your rules of court. So this is the provision. Okay. So you wish to say JSB has another 7 days to go because 1 week ago statement of claim was served on JSB, the Sendirian Berhad already. Okay. So you see, now Penny said there is a contract, there is investment. I never get my return. You are acting for JSB. Yes, I know you are for JSB, but you cannot simply strike out without ascertaining the truth of the whole matter. Your paramount duty, number one, is to the court first. Number two, to your client. So I think the distribution of the mark 13 is not mere discussion about striking out, but rather you must I think this one you must make a discovery order against Penny. Okay, even though your client Mati say that, oh, you know my side, I'm very clear there's no contract, nothing. But remember, striking out pleading, plain and obvious case, and somehow you got only one chance pursuant to your section 28 or section 68 CJA. So that striking out, if you do not do it properly, wow, then you go full trial, waste your client money, and then you get scolding for the client, and then you have to take legal responsibility. In a safer approach, and that's why I put a remark here, safer in advising the client in real life, this is probably what I will do as well. So I will discuss with JSP. Why not? You said so, right? No contract at all. So what our side will do, we we put forward a notice to produce. This is a so-called easy way lah. This is pursuant to your Order 24, Rule 10. Without going a lot of hassles, okay, you go through a notice of produce, you file, and then you serve to other side solicitor. Ask them to give you the written contract. If let's say there's no written contract, you are well and safe to go for striking out because you have a plain and obvious case because now you can so sure and so 100%, oh, what my client say is 100% truth, no doubt. Okay, whereas if you do not do this step, not to say cannot at all, you just try your luck lah. You put in Order 18, Rule 19, strike out. You find your affidavit, 100% believe what your client said, but eventually the affidavit in reply on part of Penny's lawyer put inside the this one written contract duly stamped. How? No need argue lah. I mean, just withdraw lah. I mean, you cannot file again. So this is like, ayo, malu lah. Not just malu it's concern to your professional professional integrity as well. You did not exercise due diligence in this matter. How can you just blindly 100% follow what your client say without, like I said, ascertaining the facts. Okay, so notice to produce, order 24, rule 10, you just have a look at that, and the form is actually provided, behind, in your form 41, and then you serve to Penny. Okay, so within 4 days, something like that, and then within 7 days after the service of the what we call the documents, if Penny does not object, you must produce. Okay, you must produce. This is a very simple rules. Why I prefer this is because you see the fact clearly mentioned, inside statement of claim. Penny said there is a contract, so there's no need for you to go for ordinary. You want to discover for your specific documents, or that you don't have to. You just mention. Okay, you mention inside your statement of claim there is such thing called contract. Okay, there is such thing. There's an investment contract, something like that, and then you will promise with return. I want to see it. I want to inspect it. As simple as that. So, and this is the case I found from Citibus Ong Boon Hua. It was held that the party to whom the notice is given must produce the documents unless he can show good cause. Why the inspection? Why it not be allowed? Okay. So be clear with that, notice to produce. And of course, like any other discovery order, is subjected to necessity rule. But in this case, I will submit this is necessary because the entire course of action from Penny is based on this existence of contract. If there's no contract, you cannot sue. How can you sue just by something? Okay. And then subsequently is apa nama is your striking out. I think striking out is fairly same with the previous discussion. Okay, no much problem. Hmm. You give me a minute. Let me just go to washroom for a while. Then I'll come. Just give me a minute. I'll be back soon. Okay, let's continue. I think we finish it. So Wentworth, Sendirian Bahar, I hope you guys don't mind with a little bit overtime here. So Wentworth is a company involved in the business of textiles. Albert, Benedict, and Chuck are shareholders and directors of Wentworth. Chuck is a good friend here of Albert and constantly involved, informed Albert that he had great ideas to develop business of Wentworth and was interested in taking a bigger role in the company. So this Chuck is quite grandiose lah. He's very confident with his ability. He recommend himself. So what happened next? On 31st January 2016, Chuck was appointed as a deputy managing director of Wentworth. So as DMD, Chuck was meant to assist Albert, the managing director, because they are friends, isn't it? So in matters relating to developing the overall strategy and commercial objectives of Wentworth. So as he claims so. So, however, within 2 months of his appointment, Chuck started to take various steps to destabilize Wentworth and even attempted to oust Albert as the managing director. So there are so not so good doings by Chuck. So it was discovered that Chuck was liaising with Wentworth's customers without the knowledge of the boards of directors. So he's making some he's breaching the fiduciary duties as deputy MD here. So as such, Albert and Benedict cannot tahan lah. So they took steps to terminate Chuck's appointment as deputy MD here. So after Chuck's termination, what happened? Oh, so Chuck is a little bit shameless here. He continued to write to related parties of Wentworth and represented himself as the deputy managing director of Wentworth. So Chuck also approached certain customers and attempt to negotiate contracts with them on behalf of Wentworth. So Albert and Benedict have written to Chuck. Again, there's a part of non-legal approach, that means negotiation already failed. Chuck not responded to those letters and continued to act on his own, not listening to whatever Benedict and Albert said. So Albert and Benedict had no choice but to think of taking legal actions against Chuck for breach of fiduciary duties. So we are to advise Wentworth, the company as a whole, what are the steps they may take to prevent Chuck from further holding himself out as the deputy managing director of Wentworth. So this is quite a clear question about injunction. Okay, but in to making yourself looks a little bit more outstanding in your answer, I think it would be best for you to touch a little bit, not just ex parte injunction, but you must also cover a little bit about ad interim injunction, as well as a little bit on the perpetual prohibitory injunction that is granted in trial later on. Okay, why you want to do so is because you must think for the interest of the client and also real life practice also. So you want Chuck to get you want Wentworth to get rid of Chuck completely and forever. Okay, so what Wentworth is advised to do is, of course, ordinary approach will be send a writ of action as well as fine a SOC against Chuck. This could be easily done online now, and then service so long he does not evade his service. And then after you have that writ, I mean the registration of the suit number, okay, you can file in an urgent ex parte prohibitory injunction pursuant to your Order 29, Rule 2, ROC. So every injunction, regardless of its type and name, is subjected to your Order 29, Rule 2. Because the matter told us that harms already happened to the company and it is on urgent basis, cannot wait. So need to file in usual practice with this I think is not covered in your syllabus. You have to put in a certificate of urgency okay. Uh, against Chuck. What is the purpose here? To stop him and to forbid him, to prohibit him from acting as or pretending himself like a deputy MD of the company. So usually the so-called ex parte injunction, because it is only heard, I mean the court only called Wentworth, probably the directors, Albert and Benedict, to go to the court and hear one side story. Chuck will not be called ex parte. So only Albert Benedict's version of the story will be told here. Usually in these circumstances, the injunction, because it's an equitable relief, it will not last long. 21 days lifespan. So in practice, the court during the ex parte hearing, okay, after hearing your submission and all that, your reasoning, and then the court, for example, at the discretion, granted the ex parte injunction, will subsequently on that particular date fix a date. Hey, next date, before the expiry of 21 days. What is the date today? What is the date today? Forgot. 17. Okay, 17. 21 days means okay, before 8 of November. Okay, I fix a date on 1st of October. For check together, we have to decide the matters together. That is another date for inter partes hearing. Usually why the court do so is because later on, ex parte injunction operates on its own. At interim injunction, will need to you have to file in another new application. So it becomes double work for the court for the same method. All you want is to stop Chuck from go and tell the customer that he's still the deputy MD, and also go and tell some lies to the customers, all that, right? It's the same method, so no need. So make it very simple, eh? And you must also plead for this perpetual prohibitory injunction in your statement of claim, very important. Okay, and in prohibitory injunction, I think it's best for you to discuss a little bit of principles of law. Order 29 itself is just a procedural application, okay? And the real, because the injunction, like we know, is a specific performance, is an equitable relief. So it is vested inside your main statute, section 52 SRA. Okay, very important. I think you highlight a little bit. Okay, and you submit that prohibitory injunction is the best legal method now lah, because Chuck refused to accept the letters at the preliminary stage. So, and then you apply, how you apply ex parte prohibitory injunction is by notice of application supported by your affidavit. So you go to your Order 29 Rule 2, very important. Okay, Order 29 Rule 2. Okay, and then again, notice of affidavit must also have one what we call um affidavit, So the compliances to the requirement is very important. Okay, for example, you must have uh serious question to be trial. All that is actually inside your affidavit. You must plead all that so that the court, when they listen to you or listen to your evidence on the surface of prima facie, can decide an ex parte injunction to be entered against Chuck. So what are the reasons? Serious question. Yeah, in this present case, it's very serious because Chuck was fabricating, impersonating himself as deputy MD, even though he was being fired. Okay, so compensation is not sufficient as well. You must always think, whenever court is doing equity, the all this is actually means the court do equity in the event all the methods or all the alternative or all the compensational way is exhausted. No other way lah, but I have to force you to stop. You get me? So please and then compensation is usually insufficient lah. Usually injunction um defamation is quite popular lah. Stop whatever nonsense you put inside the social media. Stop immediately. I sue you later for damages. So, something like that. Otherwise, my name will get foul very soon. So, undertake to damages. Whenever you ask for equitable remedy, must always think, especially injunction, undertake to damages, full frank disclosure, form application, all that is compulsory. Every single injunction will involve this sort of elements. Why? Why? Because whenever injunction have been granted, if let's say it's wrong, you are doing injustice to the other side already without full trial. You get me? You stop people. you are refraining, you are actually breaching the constitutional right, okay, freedom to life of an individual. For example, in defamation case, you prohibit somebody to say it. You there's a infringement of freedom to speech. So this one you must undertake. If you give wrongly or actually at the end of the day, it shows that it's actually you are the top officer, you are the foul playing individual. You have to pay. So this is you sign lah. You cannot argue. I have no knowledge. I have no recollection. I don't know what am I doing. You already signed. You have to pay. So the balance on hardship must be on when both. It cannot on uh, like equal. Chuck also in difficult position. The scale must be tilted. Wow, this act is seriously causing a lot of difficulty in my life lah. Okay, for example, he's keep on defaming me inside the social media, saying that this Dr. Chi here is not handsome lah. He's having a lot of bad habits. Not good in teaching, all that. Wow, every day he give one post, and then people read and share. So my hardship, how every day I have to say, see, so not fair, huh? And full frank disclosure, like I said, every single affidavit must be full frank disclosure. Otherwise, you will be held hostage lah by your opponent. Okay, do not act smart lah. The usual practice is do not act smart because most of the time the opposing party is smarter. Okay, and you must have prompt application. Okay, cannot delay. Hmm. So, should this ex parte injunction is granted, it shall lapse 21 days. Okay, this is pursuant to your order 29, rule B, rule 2B. And the said injunction order must be served to Chuck. Otherwise, whenever the court gave order, you must you must obey. Otherwise, you can file committal proceeding, committal proceeding towards a civil case is no longer, I mean, sometimes you need to go to prison, for contempt of court leh. So this one very serious. So whenever there's an order, you must serve to other party. Okay, otherwise you play around with, no, not to say you lah. I mean some other fraudulent party may play around with this rule and then taught this person to go to committal proceeding and go to prison. Okay, so not fair lah. So I discussed earlier, the court shall fix inter parties hearing date for an interim injunction to maintain state to decide whether the injunction should be maintained status quo or not. Yes, I give you 21 days, but before the expired, Chuck must also come to give his ground why I continue to act as a deputy MD. Is that the fact that I received or not this termination letter, or did I actually receive instruction from other directors of Wenwolf or not? So these are probably the consideration of the court must have lah before granting blindly an order. Okay, very important. And in a statement of claim, filed by Wenwolf, this is all this help you to develop your answer. You must pray for a perpetual prohibitory injunction. Otherwise, all this interim ex parte injunction is not lifelong, It's not last forever. Okay? So when Wenwolf wins the case, Chuck will be forever barred to call himself until further appointment, okay, as deputy MD. Okay. And 6B, I think we almost come to end. Very good. A trailer lorry driven by Tan went out of control on highway and swerved into Dora's land, hit a telecommunication tower installed on land. The tower collapsed and fell on the roofs of his house, which is adjacent to Dora's land. Ang has commenced an action in court for negligence against Dorai. So advise Dorai on the procedure he should adopt if he intends to claim against Tan in the same action as he was sued. Okay? So this question here, we have no doubt, no doubt, no issue of adding core defendant. This one is 100%. As uh, he was sued by Pang. I mean, you want to claim contribution or indemnity, okay, from Tan as a lorry driver, because now Pang sue Dorai, and Dorai, okay, he cannot argue that the tower is on his land and memang collapsed already. So he cannot argue on the point. So he need to get indemnified. I mean, he need to get done to responsible to pay the money so that he can pay Pang. Okay, so this is the whole procedure. So third party proceeding. So first foremost, don't forget your fundamental rules, although it looks trivial, but somehow or rather it decide your fate, sometimes. Okay, so enter appearance first, and then before, let's say for example, before you file any defense, usually you do not need the permission of court to go for third party proceeding. Reason is being simple, because you wanted to formulate your whole idea is like Pang put the blames on Dora, and Dorai put the blames on Tan. The whole strategy is played as such, You suddenly, you cannot file a statement of defense without first issue a TP notice, If you issue a TP notice, after your defense, usually the court will see it as an afterthought, pemikiran semula. So you might be caught with problems. The plaintiff can oppose, the third party can use this ground to oppose your application also. So in usual scenario, it's very important for a solicitor to get all the facts complete to plan their strategy at their very beginning of the case. Otherwise, susah. You need leave, and then suddenly the leave is not granted because your affidavit challenged by the opposing side. The other party, Pang probably friend of Tan, for example. Okay, I don't want Tan to get responsible. Since this tower is on Pang's land, clearly you need to pay already. What? Me and Pang close friend, pakat, habis. So I oppose lah. I oppose your application. Then you have no grounds. So you must highlight the distinction here. So Dorai may issue TP notice. All that is found in your Order 16. So no leave required if Dorai issued this TP notice before filing his statement of defense. Otherwise, it will be like a afterthought. And it complicates the matter because you later on you need to amend your statement of defense one. Otherwise, how you put the how to say the claims to third party? Okay, so because defense statement of defense, usually what we do is we rebut every single allegation. Okay, we say no. We produce proof that we don't do. We are not negligent. It's not my fault. Something like that. So difficulty is there. So leave is required if, let's say, Dora has served his defense. This is pursuant to your Order 16, Rule 1, Sub Rule 2, and again, is by ex parte notice of application. So all relevant course paper, if let's say, for example, the leave is granted already, during the third party notice, you need to know, you need to let Tan know as a third party what actually happened. Otherwise, he will not know. So how do you make Tan know what is the ongoing matters? Is by providing, okay, look here, there's a read issued by Pang to me. I mean, I'm Dorai here, and this is the statement of claim. So I put forward to you. So now I issue this third party notice because Dorai, me, wanted to put the blame for you, and you know what is the claims about. Otherwise, if let's say Pang is claiming 1 million, without me looking at the original read and also statement claim filed by Pang, I wouldn't know how much to contribute. I wouldn't know how much to indemnify. All right. Okay, correct or not? So logic behind that is same lah. And then the third party directions shall be given by the court. And the court is at very large liberty to decide. For example, now you just imagine by right, your order 35 said that plaintiff start his case, then defendant enter defense. So now we have a third party. So how third parties, when they are going to have a chance to cross-examine the plaintiff witness, because as a third party, let's say you are acting for third party, you have a strategies either to defend himself or to quash completely Ang's case. So that there's no liability imposed on the right, no liability on the right. That means no liability on me. So there are two ways to work on this matter. So the court will give directions to that particular lawyers on the spot. Usually, from what I've seen, it's like that. Okay, so the case is Zhi Haitong against Rambler Cycle. Okay, last question. What's time now? Wow. Okay, so Ahmad, who is a GM of Syarikat Kappa, comes to see you and informs you that Syarikat Doremi obtained judgment against Kappa 6 weeks ago. Okay, see times 6 weeks ago for 200,000 for goods sold and delivered by them for a project. He informs that their previous solicitors only informed Syarikat Kappa of the judgment last week in the ground of decision. Okay, the learned session court judge stated that she did not believe the testimony of Ahmad, who had testified that there was an oral agreement of Ahmad and GM of Syarikat Doremi, and that amount all need not to be paid. So the learned judge, session court judge, actually ruled that there was no contemporaneous documents supporting Ahmad's testimony. So how to say, our client Syarikat Kappa actually lost the case here. So Ahmad, as the GM of Syarikat Kappa, informs you that he had just discovered a new piece of evidence. See, there was actually an email to him, so from Syarikat Doremi at the material time. So showing that Doremi had stated the amount of 200,000 was not owing, but to use as a payment from them to Syarikat Kappa for another project. So Syarikat Kappa now seeks your advice on the following. Okay, so you can see there are some key points. 6 week monetary amount is 200,000 from session court, and lost the case. So this is about an appeal matter from subordinate court to high court, and there is an issue of whether new evidence is admissible in appellate stage. So we'll see the question one by one. So one, whether Syarikat Kappa may appeal against the decision of session court and the procedure for doing so. Okay. So this is a clear case from session court wanted to go to high court because Kappa lost the case. So Syarikat Kappa can actually appeal as of right. This is pursuant to your section 28 CJA, because the monetary amount here, 200,000, is more than 10,000 stipulated under section 28 CJA. If let's say, for example, the amount of money is just 7,000, okay, 7,000, you do not fulfill the monetary treasure, okay, to appeal to a high court. So what you are left to do, you must prove there is a question of law, or there's something wrong in the Contract Act 1950 that I want the court to interpret. This is called question of law. Okay, so remember your section 28 CJA and also your Hanaya against Teh Sui Ing case. Okay, so you explain he can appeal. No, I mean Kappa can appeal. Okay, so procedure to appeal is file a notice within 14 days from the date of judgment. So again, the time is essence here lah. Okay, now it's already 6 weeks. Yeah, you have good reason because you just know. Okay, probably there's some communication gap in between, so we don't know. But the law stated, Order 52, Rule 2 said it's only 14 days. So what you need to do, whenever I say to you, there's an issue with uh, time, first application, extension of time. If it is subcourt to high court, usually the governing provision would be your rules of court, the General Order 3 Rule 5, extension of time clause, notice of application supported by affidavit. Let's say the case from High Court to Court of Appeal. Like this, Court of Appeal, High Court to Court of Appeal or Court of Appeal to Federal Court. My sincere advice, do not touch. Do not touch. Even us also very this one shallow in our knowledge because it's all different already. It's not even called extension of time. It's called motion to regularize in appellate stage for superior court lah. So very difficult for you unless you are practicing. You have gone to court of appeal many times or federal court many times. You are well versed with CA, RFC. Um, if it's not, you're just cukup makan with your order 55. You can only do the question pertaining subcourt to high court. Full stop. Okay, full stop. And then the if the leave is granted, then the notice of appeal shall be in form 111. Notice of appeal far first, then only memorandum of appeal. Remember, first step, at least you can get a little bit marks. Notice of appeal, confirm. Criminal, civil litigation, notice of appeal first. Other than that, records of appeal, notes of proceedings, all that comes later. Ground of judgment, all that comes later. Later. If you do know, also, I think still acceptable because notice of appeal is the one that come first. Okay, at least you already secure a few marks, and then it must be served. Pursuant to your order 55, rule 3, sub rule 4. And then subsequently, Kappa must file in the High Court all records of appeal within 1 month. Okay, A to H, your rule, rule 4 of order 55. I suggest you to have a look since you have several weeks left for your conditional paper. I think it's worthwhile to go through the proviso rather than just memorizing all over again the case law and try to understand why the law allocate like that. Why the law asks you to do like that? I think probably in the point of examiners, you will be impressed a bit. Okay. So Syarikat Kappa, the next question is, can avoid paying judgment sum or not? Okay. So you are to advise Syarikat Kappa can apply for stay of execution in order to avoid paying the judgment sum. So this is quite clear and straightforward. And appeal from the above question does not actually operate as stay of execution. Okay, appeal is a creature of statute. It's a creation of statute. Means you are allowed to appeal because CJA says so, or you can appeal. Okay, because Order 55 said so, you can appeal because you are not happy with the liability issue. You are not happy with the quantum. I mean, the amount of the judgment you think is too high. You think the assessment is wrong. Okay, so you appeal on this particular ground. So this one, the power given by the law. Okay, and stay of execution on the other side means the court, even though I have awarded the plaintiff the award already, that means in favor of the plaintiff, 1 million ringgit, but you are depriving the plaintiff from enjoying the fruit of that particular judgment. Let's say the appeal works as stay of execution, it will somehow force and drag the plaintiff, not just in the, for example, High Court, 2-3 years. And then subsequently, Court of Appeal, 1 year. Federal Court, 1 year. So altogether, 4 years, only he can enjoy the fruit of, how to say, the fruit of the award of judgment. It's not fair, isn't it? So the courts separate both. Appeal is appeal. Stay of execution is another thing. So you must make separate application, right? So how to make if you are on the spot, if you're not happy, I mean, the lawyers, the judgment is pronounced on the spot. So if the lawyer is not happy, taken instruction from the client, can orally apply, submit to the session court judge. I think this case is session court judge said, uh, Tuan, I want stay of execution. Okay, stay first because I want to appeal. I think it's not right to grant the award to the plaintiff right now. Okay, but of course, like I said, plaintiff should not be deprived from the fruit of his success. Okay, so the court will usually look at special circumstances when the stay of execution is granted. Okay, the principle is usually what we call is nugatory principle. That is to say that, let's say the thing go to appeal, and then eventually, let's say now plaintiff win. Eventually, if it goes to the appellate stage, the defendant won the case. Were were the subsequent winning meaningless to the one that appealed, the appellant? Okay, so rendering it to become a paper judgment, it becomes useless lah. Like the whole appeal process has no function at all because gone already. The subject matter of the what we call the let's say the land is in dispute. The land already exchanged so many hands. It goes to the bona fide purchaser, subsequent one, and not just subsequent, maybe subsequent. Habis. The appeal eventually win, also no use. This is meant by nugatory principle. Okay, and this is of course some judges refuse to treat it separate heading lah. And usually this is the case lah. The court is opined that this is a species of special circumstance. It's just one of it. It's just one of it. Okay. So monetary consideration is not taken whether you don't have money or not. The court may not really bother that much. So this is the thing. And 7A subrule 3 looks at the email, whether it is admissible or not. So this email is going to be emitted during the high court stage. That means the original trial in session court is already finished. So now you are looking at emitting email inside the high court. Usually, even though the high court is a rehearing, but you already file in your bundle of documents, pleadings, everything, isn't it? And also your witness statement. So how come suddenly you produce this evidence is a brand new one, and every new evidence can caught the attention of the judge, isn't it? So you cannot play around. So generous rule is that the judge will not usually how to say allow the admission of fresh or new evidence unless the rules of Order 55 Rule 7 is compliant with. The common law position is laid down in Leg against Marsha. Leg against Marsha is a landmark case, must remember. So 4 points here: credible, relevant, and it could not be obtained by any party during the trial stage. Okay, and if let's say the evidence is given during appellate stage, it must be an important one. It's not just a my mind evidence. It's not just of something that is no uh significance at all. So this is very important. So the email you submit that to say that the email stated in the fact, because the SCJ decide because he did not believe what Ahmad said, right? Because it's entirely based on oral agreement. There's no contemporaneous evidence to support his case. So this email is a documentary evidence, and this documentary evidence is a more powerful one than the oral evidence. So this one has the capability to overturn the decision of this current suit. So it should be admissible. Should be lah. Cannot say 100% lah. So you said should be. This is in accordance to law already, okay? And you get marks. Last question. Okay, better finish it fast. So Kumar was employed as a medical officer uh, and on a 3 years contract basis lah, from 1st January 2016 in Hospital Kuala Petaling, Sdn Bhd. So on 15 May 2016, he received a letter informing him that his employment contract had been terminated with immediate effect. So he got sacked. So the reason of that termination that given is that he was breaching the terms and conditions of his employment, but no details was given. So Kumar had no idea about the reason of his termination and informed you that he has not committed any breach and there was no inquiry before the termination. So like this, the employment law, this is substantive law. You cannot just simply terminate without a domestic inquiry, the DI. How you whenever you want to impose for example, this ground is probably on the ground of misconduct of the employee. Okay, you cannot simply just say that, oh, you're faulty, you breach the clause, that's why I terminate you, like that. So there's no procedural propriety here. So, but this is not the issue. Being dissatisfied, Kumar made a representation for reinstatement. So he won the job back, under Industrial Relation Act 1967. However, Kumar received a letter on 1st June 2017 informing that Minister of Human Resource that he had made a decision on 30 April 2017 that his representation was not fit to be referred to industrial court for an award. So Kumar met you yesterday and sought your legal advice. So this is a case of judicial review, because I think the issue here is not suing Hospital Kuala Petaling Sdn Bhd, but rather to bring this matter to industrial court. So Kumar here was denied from accessing. Okay, so the grounds, this is of course pursuant to your Order 53 ROC, and your main law for judicial review. This is very complicated. I don't think you should, uh, elaborate. It is vested inside your CJA as well as uh, your SRA. So very complicated and very niche area of practice. So the grounds is, of course, Venice unreasonableness. It is irrational for minister to deny Kumar's access to industrial court. Okay, so now actually Kumar was working with Hospital Petaling Kuala Petaling Sdn Bhd, right? It looks to me like a private company. But now what minister did, he totally prohibit Kumar from going to industrial court. Industrial court, that means the parties here will be the employee, Kumar, as well as Hospital Kuala Petaling. But without the human resource kebenaran, how to go? Cannot go. So no access to justice. So this is the reason judicial review set in order to quash the decision, to say that, oh, minister, you better tarik balik, you better cancel this decision. So Kumar can go to industrial court to seek his remedy. So this is how it works. So judicial review has two stages. Elaborate a little bit. Leave and substantive stages. Leave means because judicial review is intervention of court powers on part of executive power, meaning the court now need to evaluate the executive. I mean, we have separation of power, parliament, cabinet, execution, and also the judiciary. the hakiman. Okay, so separate powers, usually we don't disturb each other, So now you plead to the court under judicial review to ask the court to say the executive body did not perform the jobs well, whether they are illegal, uh, irrational, so not following the rules, so something like that. So that means to say you are putting the judiciary system in an awkward position, By right, I'm Hakim, you are Perdana Menteri. I cannot say you are wrong, isn't it? I cannot say the speaker inside the parliament is wrong, isn't it? There's a separation of power, So usually the leave stage is very, very difficult. Okay, bear that in mind first. So divided into leave stage. That means to say the court must have granted permission. So that is involved. So the timing to get order 53 rule 3 sub rule 6, you look at it, it must be within 3 months from the date where the decision, because we have two dates, 1st of June and also the 30th of April. So which date? We use June punya date, very important. Okay, so now the exam is 2017. Okay, we should use the June date. It's not the. Let me make a correction. Okay, so it's less than 3 months. So it's within the time. If let's say, for example, Kuma is running out of time, he must file an extension to get time. And you must look at the specific provision of Order 53, Rule 3, Sub Rule 7. The conventional Order 3, Rule 5 has no application. Okay, because this is a specific provision to apply on judicial review, order 53. Okay, same if you want to add party inside the judicial review, you must look at order 53 rule 8, if I'm not mistaken. Okay, you must not look at the order 15 rule 6, cannot, wrong. Okay, so this is how it plays. And then how you do is you file application uh pursuant to order 53 rule 2, that is in your form 109, and the granting leave is entirely at the discretion of court, and it is compulsory. Okay, no leave, cannot even go for hearing, your case will be thrown away. Okay, so the leave, how to get? Ex parte, to judge in chamber, pursuant to your order 53 rule 3 sub rule 2. And the test here is very strict. Kuma must show he was adversely affected and have a genuine interest in the subject matter. Okay, this is pursuant to your MTUC against Menteri Tenaga Air dan Komunikasi. So the previous law standing said that as long as you have the position to sue, that is to say that you have local standby, is enough. No, now not like that. You must be affected by the decision. Now you just imagine, now the Minister of Human Resource deny Kuma from going to industrial court. What if this human resource minister just make a general statement that has no adverse effect on Kuma? That means he cannot simply bring that minister to the court, isn't it? So must have real interest, must have some foundation, and there must be some negative impact due to the decision, okay, the authority decision, and there must be a public interest of that case. Ahmad Jeffrey, okay, public interest means usually involve a public. We look at, it's not private interest It's something like I want to build a jalan. Actually, this one is my residential area. Populated by so many people. Suddenly want to build a main road, whereas my kids want to cross the jalan also becomes very dangerous. So that means to say involve many people, public community interest at large. Okay, so Kumar, even though may show that he was adversely affected, okay, no doubt the Minister of Human Resource decision is not so favorable to him, but he cannot show what we call public law element because he's engaging with Kuala Petaling Sendirian Berhad. So his how to say his contractual basis, it's a private interest, This decision only concern with the interest of Kumar. Finish. The Human Resource Minister did not issue a general uh, statement saying that all the medical officers cannot go to the industrial court. He did not issue this sort of statement that involved public at large. It only targeted Kumar. So my submission is Kumar will fail in lift stage. Okay, cannot go to substantive stage. Okay, finally we end our classes. I hope this is enjoyable. At least you're tired of reading. You can just listen to what I say. Okay, I will see you. I think everybody needs to go. I need to stop my